Hey everyone, and welcome to video 3.2.6 for the Legal Studies Guy. Our quote today from Bill Copeland. The trouble with not having a goal is that you can spend your life running up and down the field and never score. So bringing in a bit of, sports theory to this, but yeah, effectively, if you're running around playing, the game of life and you don't really have a goal with where you want to get to or what you want to do, you're just going to sort of be a bit aimless and potentially a little bit pointless with everything that you get up to. So the idea being that it doesn't need to be anything major. You don't want to need to have to, want to change the world, but it is worthwhile having a little bit of an idea of where you want to get to, so that you can then match your actions towards the outcome that you want. So if you haven't thought about your goal for this year, and particularly for legal studies, now might be a good time to really think about that to start driving some of your work in term two. 326 today, and we're talking about roles of key personnel in a civil dispute. So, previously in criminal law, we did roles of key personnel in a criminal dispute, and now we're shifting over to exactly effectively the same point, but for a civil dispute. So we're looking at the judge or the magistrate, including the role of case management, which I'll talk about, the jury, and the parties. Interestingly, and I'll get to this, the only skill that references key personnel is this one, 323, which is compare the roles of key personnel in a civil or criminal and civil case. So that's a new skill added on this year into this new study design. So we are going to look back at some of those criminal roles and just look at how the role of parties and the role of the judge, etc., will change slightly across those two different areas of law. There is no key skill listed in civil law around analysing the roles of key personnel. Like in criminal law, the key skill was analyse the role of key personnel in a criminal dispute. That isn't listed for civil dispute, and they're not mentioned in any of the other key skills, but we are going to just look at, again, that same deal we did in criminal law around what they do versus, some of the limitations of that, because I think it is important to consider the understanding how to analyze them, because I think that will be something that potentially comes up in exam questions, considering that's the skill for criminal law as well. Effectively, what do the key personnel do in a civil dispute? That's what we're going to be able to answer at the end of this. So first up, we have the judge or the magistrate. If you remember in criminal law, I did these as separate slides just because there is a fair difference. Every criminal trial has a jury, so the judge has a role around directing the jury. In civil law, juries being optional means there is, to a degree, more similarity between the role that what judges and magistrates play across the different courts in the court hierarchy. Ultimately, the central premise or central role of a judge or a magistrate is to be that impartial third party. Same as criminal law, they are enforcing rules of evidence and procedure equally. So running the trial or the hearing when that occurs, but also and enforcing rules of evidence around admissibility, which might come up pre-trial as well, and the rules of procedure and applying them how they best see fit to the dispute in front of them. The judge will decide on questions of law. So again, that could be around the admissibility of evidence, the meaning of certain words in statutes, whether precedent applies in certain situations. So the judge will be responsible for those questions of law. They are the impartial third party. They are the legal expert in the case, or the preeminent legal expert. If there is a jury used, this is obviously just for the judge, not for a magistrate, because there can be no juries in the magistrate's court. They will direct the jury, if there is one, on what their roles and responsibilities are, burden of proof, standard of proof, application of the relevant law. We'll talk about this in more detail in a couple of slides. Judges and magistrates do possess significant case management powers in civil law that are different to the application of pre-trial processes, etc., in criminal law. So very important that we understand those, and we'll unpack them a bit further. If there is no jury present or always in the magistrate's court, the judge has that central role of deciding on a verdict and a remedy. Even if there is a jury present in defamation matters, for example, the judge will still decide the remedy because there's a lot more complexity around deciding how much someone's reputation's worth, that perhaps non-trained, non-legal experts shouldn't do. So, generally speaking, if there's no jury, the judge is going to be the person who hands down the ruling, hands down a judgment at the end of a trial or a hearing if one occurs, or the jury might do that in some instances. I've also got a magistrate-specific role, just in case it's worthwhile having that little bit of extra depth. There is this process that can occur in the magistrate's court called an early neutral evaluation. And like we know with the task word or the skill of evaluating, where we have to give some kind of judgment at the end of an evaluation, in the magistrate's court, generally matters over $50,000, so in that $50,000 to $100,000 range, they can be ordered to go to this thing called an early neutral evaluation, and that's where a magistrate will basically look over the case, hear submissions from the parties, but do it in a bit more of an informal way. And do it generally a lot more on the papers, so through written submissions and looking over some of the evidence that's already been presented. And the judge will basically tell the parties who they think is going to win. If you go to a hearing, so they're giving an evaluation, but it's neutral. It's a third party. The magistrate will say, "Hey, if you go to a trial, if you go to a hearing, and don't settle this yourselves, I think this is what the outcome will be." And again, the whole idea is that incentivizes the parties to settle, particularly the party who's told that they might lose. It incentivizes them to look to resolve the matter themselves, generally within 7 days of that evaluation, to avoid having to use the resources of the court for a full hearing. So all around efficiency, and again, trying to reduce the load on our court system. It's worth noting that if a magistrate gives an early neutral evaluation and the parties don't settle and resolve the dispute, a different magistrate will then hear the dispute, because obviously that first magistrate has then already developed some opinions and not necessarily opinions, some arguments based on what they've been presented. So if the parties don't want to settle still, it will go to another magistrate to have a free, unbiased, open look at the case and to hear that hearing. So, case management. Now, this was a really important note in the 2016 examiner's report, because up until then, the primary teaching point around the judge or the magistrate was we just drove home this idea that a judge or a magistrate is an impartial third party, impartial third party, impartial third party. And what examiners said was coming through in answers more often than not is that because we kept saying impartial third party, impartial third party, impartial third party, people were putting sort of in answers that judges were passive, that they had no involvement in the case, that judges were just like letting parties do what they want and then trying to figure out a decision at the end, as opposed to understanding that judges do have significant powers of case management. So judges have a really active role in resolving civil disputes, as opposed to just sitting back and letting the dispute come to them. And this is why it used to be a separate dot point. It was for the study design up until this year. This is why it clearly says including the role of case management. And that means because case management is listed in the study design, you could get asked about the judge's role in case management. So you could get asked that as a question, which means you need to know that in specific detail. So judges' case management powers. And what we're talking about when we say case management is from effectively the moment a civil dispute is filed with the court, so it's initiated with the courts through a process known as filing a writ or an originating motion, to basically say to the courts, hey, I have a dispute that I want you to resolve. Case management will start effectively from that point. And the whole idea of case management, obviously, is that we try and get the most efficient and effective solution to a dispute to maximize the resources of the courts. This is a common thing we talk about. So, it's going to include things like mediation and stuff that we'll get to in a moment. Now, this all comes through under the Civil Procedure Act of 2010, where judges get those powers from. And I'll show you a look at what that looks like in a moment about that specific Civil Procedure Act, because it is lengthy in terms of the powers they're given, and then we can try and summarize that down into some specifics. In practice, what does it look like? In some Supreme Court lists, for example, once a writ is filed, so once a case is initiated, a judge will get immediately allocated to that, and then the judge will meet with the parties as soon as they can to basically give first directions around when things need to be filed by, start setting timelines, and to try and get the dispute resolved as efficiently as possible. In some Supreme Court lists, particularly like commercial, so business disputes, commercial law, potentially contracts, things like that. Often that judge who does all of that case management, so that could take well over a year by the time you're getting through the discovery and disclosure phase with both parties. Parties are requesting documents from each other through court order. There's the sharing of the evidence they currently have. That's stuff we used to have to learn about, but we don't anymore. In those lists, like the commercial list, the same judge will manage that entire process and then will also hear the trial if the parties can't resolve the matter themselves. So that's like having one third party who knows all the ins and outs of the case and can deal with it the whole way through. It's different in, say, a personal injuries list where a judge will manage all of the the pre-trial stuff, will case manage, will work with fixing timelines, arranging effectively length of trial, timetabling witnesses, supporting parties with their obligations under disclosure of their evidence, parties requesting documents from each other, all of that. And then if the parties don't resolve that dispute themselves and it goes to a trial, it will be given to a different judge. So depending on the list it's in, the judge might handle case management and the trial, or the judge might handle case management and a different judge will handle the trial. That's not super important that happens or that changes. It's just around the fact that there will always be a judge more or less allocated to a case to then case manage it, again, around that efficiency and effectiveness of our justice system. So this includes like holding things like directions hearings, case management conferences, giving directions and orders to the parties, and yeah, like that could include, and we'll talk about it in a moment, that could include like disposing of some issues or, advising the parties, encouraging the parties to actually go and settle their dispute. So pretty significant active role a judge plays, not that passive role that perhaps suggested by them being an impartial third party. Now, how I would sum it up in simple terms is I like this sort of phrase here. When we're talking about the case management powers of the judge, we can say that effectively a judge can make any order, so really important, can make any order that they believe will lead to just, prompt, and economical resolution of a dispute. So we're talking just is really like, we know another word for fair, prompt, and economical, so quick, ideally as quick as can be, and economical with as low cost as possible, very much linked in with access there. And ideally, case management being applied, by expert judges across the board, there's a sense of equality as well. So I would sum up the case management powers of a judge like that. What do they actually look like in the Civil Procedure Act? Well, if we have a look at the Civil Procedure Act here and we look at Section 47, this section is titled Judicial Powers of Case Management, overarching purpose, and there's obviously much more specificity in each section of the Civil Procedure Act. But you'll see here, this is the list of effectively the overarching purposes of case management. And it gives the power for judges, so without limiting the power of the court, for ensuring that a civil procedure is managed and conducted in accordance with the overarching purpose. The court may give any direction or make any order it considers appropriate, including or such as to, in the interests of the administration of justice, if it's in the public interest, they can give any order that can place limits or restrictions on the management of the proceeding, the conduct of any party. They can give any directions to ensure it's conducted promptly and efficiently. They can try and resolve matters as early as possible. clicking through really quickly here, but you can go and look this up yourself. They can decide the order at which things are resolved. They can dispose of some issues and just say, no, we're not going to bother hearing about that. There's no point. They can encourage the parties to cooperate with each other. This could be through ordering perhaps mediation, for example. So using appropriate dispute resolution, they can encourage the parties to settle. They can decide with, whether we want to use technology, fixing timetables, dealing with as much as we can on the same occasion, limit the number of witnesses, limit the time witnesses can attend for. As we can hopefully see here, the powers that the judge has and magistrate as well, really, really wide ranging. That Civil Procedure Act gives them a lot of scope, and it's therefore much easier just to describe it as, hey, the judge may make any order at all, give any direction that they believe will lead to the just, prompt, and economical resolution of the dispute. What are some specific orders that therefore a judge or a magistrate might give? They might order the parties to attend mediation. Can they order the parties to resolve their dispute at mediation? No. But they can order the parties to at least try and order the parties to attend mediation. Noting that later on down the track, say if you lose your civil dispute, if you've initiated it, and you were, I guess, offered a settlement or you didn't engage appropriately in things like mediation, there's a chance you'll have to pay a greater percentage of the other party's costs because of your conduct. So there are ways that you can be held accountable for your decisions regarding the orders a judge gives you. But the judge can order you to go to mediation. The judge can make those rulings on the admissibility of evidence and basically say you can't use that evidence isn't allowed, should that be admitted or not. The judge can get rid of some issues, as we said. They might be like, hey, why are you bothering to argue that? Maybe it's a class action and you're arguing that there's not 7 plaintiffs, and the judge can just pre-trial go, there's definitely 7 plaintiffs. We're going to dispose of that issue. We're not going to bother arguing it. Moving on. Judge can fix timetables, really important point around the prompt resolution of a dispute, putting time limits on parties. If parties don't meet those time limits, then there can be consequences, and limiting the number of witnesses at trial as well to make sure that parties aren't unnecessarily calling people to perhaps lengthen the dispute and make it cost more money for the other party, which helps with that economical resolution of the dispute as well. So really wide-ranging powers that a judge holds. Role of a jury in a civil dispute, deliver a verdict. So juries in a civil dispute, there are only 6 of them, randomly selected from the community, much like a criminal dispute. They are optional. This is a really important point. We don't use juries in every county and Supreme Court civil matter like we do in criminal law. They're optional. If a party wants them, a party has to be prepared to pay for them effectively. If one party wants it and the other party doesn't, the other party can technically argue that there shouldn't be. But generally speaking, if a party wants a jury, they will be able to have one. They will just have to foot the bill of what that costs. And then once there is a jury, if there is one in a civil dispute, it's the same role really as criminal law. Objectively listen to evidence, follow directions from the judge, deliberate until you reach a verdict, liable or not liable in this case. And a real difference here that'll come up in that comparison is that they will be required to determine damages in most civil matters that a jury hears, which is a really big difference because our jury's never deciding on a sanction in criminal law. Parties, this is where, in a comparison with criminal law, we're likely to get the greatest differences in a way, and that's purely around the fact that obviously one of the parties in a criminal matter is always the state, the prosecution, who is bringing the matter, whereas in this case, in civil law, we've got individuals, or individuals and corporations and groups and the like. So the two parties in a civil dispute are the plaintiff, who is making the claim, and the defendant. And a really big feature of civil law, is this idea of party control. So it's an adversarial system. The judge isn't there to try and, ask questions and do their own investigations and inquire their way to figuring out what the truth is. It is the responsibility of the parties to gather their evidence, develop their arguments, and then present that to the court so that after the parties have had that adversarial approach where they're pitting their arguments and evidence against each other, the truth will come out and that will be the judgment handed down by either a judge or the verdict given down by a jury. So party control is really important when we talk about plaintiff and defendant. The plaintiff is bringing the dispute, so making the claim, which therefore means that they are holding the burden of proof, and that is on the balance of probabilities. What is more likely to have occurred? The defendant, on the other hand, is then going to be generally testing that evidence, and they may present their own evidence naturally and their own arguments that paint a different story or a different perception of what the plaintiff is arguing. Obviously, there's a greater requirement for a defendant to do that in civil law because the standard of proof is lower. You just have to create enough doubt in criminal law to therefore no longer be beyond reasonable doubt. In civil law, it's a real much more, we don't use numerical terms, but it is what is more likely, the balance of probabilities. It is much more 50-50, which means the parties are in a way on a bit more of a level footing. A really good role of the parties that you can use in an answer is that parties are subject to the overarching obligations. Now, this is the Civil Procedure Act, which I showed you for case management a minute ago. The Civil Procedure Act has a really important section right at the start, which says everyone involved in a civil dispute, so the parties, their legal practitioners particularly, are subject to these overarching obligations, these overarching rules that they have to follow. So if you're talking about a role of the parties or their lawyers, which we'll talk about in the next video, a really good one you can say is that, they're subject to the overarching obligations. One of their roles is to uphold those. What are the overarching obligations? As I said, any person who is a party or a legal practitioner, they are effectively cooperation, acting honestly, making reasonable claims only, not doing anything that isn't working towards resolving the dispute, no deception, use reasonable endeavours to resolve the dispute. So mediation, if you're ordered to it, for example, try and ensure costs are reasonable, minimise delays, narrow any issues that you can. So the judge has the power to hand down orders regarding that. You have the obligation to effectively follow those orders because they are court orders, but also because you must meet the overarching obligations and disclose any existence of documents that you possess, so the other party can see all of the evidence and you can see all of the evidence, and hopefully as a result we're going to get the fair and just outcome and parties are on that equal footing. So really, really good role that you can put out there in an answer about the parties is that they have to meet the overarching obligations, such as cooperating with the other party and taking reasonable steps to resolve the dispute. It's a really, really clear, easy one that you could use. Now, our skill here is a comparison. Can be different in different subjects. Like sometimes it will say compare and contrast if you want to do similarities and differences. Compare might just mean things that are the same. Been a while since we've had compare as a direct word on the study design, but history suggests back into old legal studies exams that if we see the word compare, it wants us to do both similarities and differences. So that's a really important thing I want to highlight. And I would suggest that if you did get a compare question on an exam and you just did a similarity, that there's probably a reasonable chance that you are precluding yourself from full marks, that you'll need to do one of each or more depending on the marking structure of the question. How rock solid is that? Just my theory based on past exams from quite a long time ago, but better to be safe than sorry in this instance, I think, rather than waiting or just doing similarities, waiting to see an examination report and finding out that's been interpreted differently. So we have here in front of us a big section of similarities and differences. I won't dwell on the similarities too much because they are effectively those roles that we just talked about. So unbiased third party judge, make final decision, management of pretrial processes, so disclosure in criminal law for the prosecution to disclose to the defence versus discovery disclosure in a civil matter. So there is disclosure in civil matters as well. Juries deliver verdicts. Plaintiff prosecution always bears the burden of proof. Obviously, a big difference being that plaintiff is generally an individual or a company, as opposed to the prosecution being a function of the state. And the defence, primary focus is rebutting evidence. That's a similarity, bearing the burden of proof for any specific defence that they run, and hopefully engaging in that pre-trial negotiation. The important thing is to highlight the differences, though. Civil judges will hand down a judgment if there's no jury. Criminal judges will not. It's a really important point. And generally, civil law has more flexibility in case management, particularly around ordering mediation, which you can't do in criminal law, because there is more flexibility for individuals to resolve disputes themselves, whereas criminal law is much more rules-based around evidence, procedure, etc. So that greater flexibility means generally greater case management powers in civil law, to order more things, to order more issues be disposed of, etc., etc. Jury, it is technically hard to work out whether the fact a civil jury is optional is a different role, or is it, the key wording is compare the roles, and the fact that a civil jury is optional isn't really one of their roles, it's just a fact. So ideally, when we're talking about differences between their roles, we would focus on, let's say a jury is used in civil law, how will their role be different? While they're deliberating on a different standard of proof, and in some civil matters, they will be handing down damages, whereas they will never determine the sanction in a criminal matter. So I don't think if you're asked for the similarity or to compare jury in a civil and criminal matter, their roles, I think it would be risky to talk about the fact that they're optional in civil matters, because that's not really a function or a role of them. It's just a fact about how criminal matters work versus civil matters. So I would focus more on things like different standard of proof that they're deliberating on, and the fact that they will hand down damages, whereas a criminal jury will never determine a sanction. Plaintiff will need to organise their own legal representation, whereas the prosecution is a representative of the state, so that comes just by nature of being the prosecution, and leading the case will change significantly based on that differing standard of proof. The prosecution bears a much higher burden than a plaintiff does. Not that the plaintiff doesn't bear a burden, but the prosecution has to be trying to run and deliver that case to beyond reasonable doubt, which might make some differences in terms of how they will conduct that. Defence is where the differences are really highlighted, and there was a question on last year's exam around that, where ideally that could have been illustrated by students, is the fact that the lower standard of proof on the balance of probability means a higher need for defendants to lead evidence and lead arguments. In a criminal case, you have the right to silence. That means you don't have to give evidence, and you don't have to in a civil matter either. But you have that right to silence. It's up to the prosecution to meet that very high burden of beyond reasonable doubt. As a result, you can just sit there and let them go and just try and throw out a few things that lead doubt, and as a result lead to you not being convicted. That doesn't happen in civil law. If you sit there passively and don't lead evidence and don't lead arguments, perhaps don't give evidence yourself, it's going to be much easier for a plaintiff to deliver their evidence and arguments above that balance of probability. So higher burden, even though they don't bear the burden of proof, higher burden on the defence in a civil matter to be a much more active, participant in terms of leading their case. As I said, I think it is probably likely that we need to be prepared to analyse the roles of key personnel in a civil matter as well. So again, I think we looked at this for criminal law as well. This case from the exam a few years ago about Tom and Guy. Tom suffering significant facial injuries and deciding to sue. Uh, Guy suffered the facial injuries and deciding to sue Tom for the cost of his, medical treatment and $150,000 in lost earnings. And we had to discuss the responsibilities of both parties. So discuss the responsibilities of the plaintiff, who is Guy, and discuss the responsibilities of the defendant, who is Tom. And again, it was decided, or was shown in the examination report, that a discussion here, which is a type of analysis, required you to both talk about what they do, which we already know, and then what are the limitations of this. And these limitations are often highly linked to the principles of justice. So a jury might make a decision based on bias and prejudice. So that's linked to fairness. The complexity of being a defendant might be linked to access. Hard to know what to do. You've got that party control, same with here, and that expensive nature as well, access, which you could talk about with the role of the judge too, leading to their more impartial aspect, meaning if you're self-represented, you can't get that support from them. And there might be, particularly between a plaintiff and a defendant, depending on means, there might be a significant lack of equality. That might be one of the limitations present in the personal circumstances of both those parties. So being prepared to both compare with criminal law, but also consider that multifaceted understanding of what their roles are, and then what those limitations are of those roles, and how those roles perhaps impact on. And here's a sample answer which you can pause and look at in your own time. I think this one's quite well written with a little bit of depth. And connects well into the stimulus material, but I won't sit here and read it and unpack it. Feel free to pause it. But yeah, those limitations hook in really well here with our ability to evaluate the principles of justice. Juries unable to put aside their prejudice and biases, perhaps. It's shocking grammar, sorry. Judge being unable to help unrepresented party. If we're constantly looking for a prompt resolution, is that going to get us the just resolution? There is equality in the sense that the judge can't help both parties. But juries are optional, meaning not all civil disputes that are similar in nature will be resolved in the same way. Does that maybe put some people at a disadvantage, particularly if they can't afford a jury, compared to a separate case where someone can? Not everyone can afford legal representation. What does that do around access? That could also be a point about equality. Differences between the two parties. If you can't afford legal representation, you're at a disadvantage. Mediation could limit access ordering mediation because it might create further delays. So lots of really good things here around how these roles and how these key personnel work might not promote fairness, equality, and access, which are therefore limitations of them, really good for an analysis. But we also know they do promote the principles of justice to a large extent as well. And obviously they do because that's how our system is ideally set up. So party control should mean we get the best evidence. The judge is a legal expert. We're trying to identify issues early, resolve issues as quickly as we can, order the parties off to alternate resolutions like mediation. Judge can, fix timetables, etc. So case management is a huge one for promoting access in terms of that justness of the dispute. So lots of things around how these roles of key personnel could limit, but fundamentally they are there to try and promote the principles of justice. And that's really, really evident as well. I didn't have anything in the cases further investigation, but I will include a link below for the Civil Procedure Act. Worthwhile having a quick glance at, just in terms of the different sections. Is pretty complex and wordy, but will help you understand a little bit more those overarching obligations, and particularly what the judge is able to do in a dispute and have that really active role rather than passive. Ultimately, you should now be able to really explain well to someone what these key personnel are going to do in a civil dispute. If there's This has been filmed in 2024. Recent resolution to the Learman defamation matter. There's an upcoming appeal related to the Ben Robert Smith defamation matter. These are prominent civil cases that have been in the news. If people want to talk to you about those, or you want to talk to people about those, hopefully you can really clearly explain what the key players, the key personnel in those disputes have been responsible for doing. Particularly, the Lehman matter at the moment, a lot of publicity around the judge who's run that, Justice Lee. It did occur in the federal court, which is technically in the federal jurisdiction, not in the Victorian court hierarchy, but did clearly illustrate the role and the power that the judge had, and the delivering of their judgment and their written judgment, and the way that they effectively conducted that trial is a great insight into the role that those key personnel can play. As always, feel free to comment with any feedback. But yeah, happy studying.